Good morning, students. Today, we are going to cover an important topic which is related to environment protection. And the topic is related to the act that has been incorporated and implemented by Government of India in this regard. So, the topic for today's discussion is Environment Protection Act 1986. In order to better understand the topic, it is required that students should be aware about the aspects related to concept of business, various types of business activities, adverse effects of these business activities on society or its related aspects, and various concerns that has been raised by public or groups from time to time. In order to ensure that students had better understanding about the topic Environment Protection Act 1986, the following aspects will be covered. We are going to discuss about Bhopal Gas Tragedy and the environmental protection. Further, we will be talking about various provisions of Environment Protection Act 1986, followed by Objectives of Environment Protection Act 1986. We will also be discussing about powers of the central government in this regard, procedures for legal proceedings, penalty for the contravention of rules and orders, offences by the companies and government departments, and bars to the jurisdiction. We all are aware that man has tried to take nature to a considerable extent, and in his endeavor to conquer nature has succeeded. The concern over the environment has grown as the quality is degrading. It has been evidenced by increasing pollution, the loss of biodiversity, loss of vegetal cover, growing risks of environmental accidents, and also the harmful chemicals in the ambient atmosphere has possessed a great threat to the environment. Due to its growing risks, various legislations are being propounded by the government. Various acts related to a specific type of pollution have been passed in India legislature. The most important statute is the Environmental Protection Act 1986, as it is the general legislation for the protection of the environment. At midnight in December 1984, when the city of Bhopal was sound asleep and the workers at Union Carbide India Limited pesticide plant were completing their routinely task, no one was aware about the tragedy that was about to strike the city. Suddenly, the families and workers living in the vicinity woke up to the sound of an emergency alarm bell and repugnant smell that filled the air, making it difficult for the local pollution to breathe. By the morning, more than 1,000 people have already died due to the gas leak that took place inside Union Carbide India Limited plant and spread in the atmosphere. The methyl isonate, that is denoted as MIC, gas in the atmosphere exposed people to severe irritation in the eyes, coughing, palaphorephem, burning sensation within the respiratory tracts, etc. Till now, families are suffering because of the horrors committed by UCIL, with more than 5 lakh people affected, while owners fled the scene due to weak environmental and civil law. Bhopal gas tragedy is considered to be the worst industrial disaster in the world, was a turning point for India and country's parliament, as the lawmakers gathered to formulate stronger norms, acts, policies, and laws to ensure that such horrific incidents do not occur in India again. The Environmental Protection Act of 1986 was enacted by the Government of India under Article 253 of the Indian Constitution. The Act came in as a result of the Bhopal gas tragedy as well as India's commitment to follow United Nations Conference on the Human Environment that took place at Stockholm in June 1972. The conference was attended by 122 nations that passed the Stockholm Declaration that contained 26 principles that focused on issues like development, environment, and the necessity of human interaction with the environment. The aim of the Environment Protection Act of 1986 is to improve and protect the human environment, most importantly, to prevent hazards from happening and causing damage to the ecology. On November 19, 1986, the Environmental Protection Act of 1986 came into force and was extended to the whole country. It was enacted under Article 253 of the Indian Constitution and comprises of 4 chapters and 26 sections pertaining to the roles and responsibilities of different government actors and agencies. Chapter 1 deals with the title of the Act, jurisdiction, and extent when the Act has been enacted, and most importantly, the definition of terms that are involved in the Act. Chapter 2 emphasizes on the power that resides with the central government pertaining to the Act, while Chapter 3 talks about actions that central government can take to protect the environment. The last chapter outlines the power of the central government to appoint officials to ensure that the objectives of the Environmental Protection Act of 1986 is achieved. The EPA 1986 enables the central government to act or give directions for process closure of a particular establishment violating the rules and guidelines of the Act, regulation and prohibition of an industry, and many such things that protects and ensures that EPA is followed. Central government can formulate rules and regulations to administer environment pollution. Environmental Protection Act of 1986 includes penalties in case there is a violation of any aspect of the Act. In case there is any such violation, the head of the department and office in charge are liable for the offense. The Environmental Protection Act has defined certain areas as restricted corridors due to the ecological sensitivity, such as Aravali regions in Alwar, Rajasthan, coastal sensitive zones, and Doon Valley in Uttarakhand. The EPA 1986 was passed with the following objectives. First, it was enacted to implement the decisions which were made by the United Nations Conference on the Human Environment held at Stockholm in June 1972. Second, creation of authority for government protection. Third, coordinating the activities of various regulating agencies, which is done under the existing law. Fourth, the main task is to enact general laws for environmental protection, which could be unfolded in areas of severe environmental hazards. Next, providing deterrent punishment to those who inculcate in endangering the human environment, safety, and health. Next, the main goal of the environment should be sustainable development, and it can be regarded as one of the goals of the EPA 1986. Another objective is sustainable development includes achieving the objective and the purpose of the act as well as the protection of life under Article 21 of the Indian Constitution. Under EPA 1986, central government has been conferred with the following powers. First, laying down the standards for the quality of the standards of the environment. Second, coordination of actions which are obliged to the state officers and other authorities under any law. Third, execution and proper planning of the worldwide national program for the prevention, controlling, and the abatement of environmental pollution. Next, restrictions to be applied in any of the industries, process, and any operation shall be carried out. Next, it is the power and duty of the government to lay down the procedure to carry forward safeguards for the prevention of many inevitable accidents which may inculcate in more environmental pollution. Next, proposal of remedies should be put forward for the protection and prevention of further accidents. Lastly, duty and power to lay down the procedures and safeguards to handle the hazardous substances. Further powers of the central government includes examination of manufacturing processes should be done, materials, substances which are likely to cause environmental pollution. Power to inspect at various premises, equipment, material, and the substances, and power to direct the authorities for the prevention and control of environmental pollution. Next, to collect the dissemination in the respect of information related to environmental pollution. Next, preparation of the manuals, codes, guides, which are considered suitable enough for controlling environmental pollution. Next, one of the most important tasks is to establish the laboratories. And lastly, serving other matters which are necessary for the central government to deal for the effective implementation of Environment Protection Act 1986. Under the power to give direction, the central government, in the exercise of powers designated by the Act, can issue the directions in writing to any of the person or any officer. They shall be bound to comply with these given directions. The power to issue directions will include the power to direct, which are as follows. First, the direction of closure, prohibition, or the regulation of any industry and its operational processes. Second, direction for the stoppage or regulation of the supply of electricity, including any other services. The following procedure needs to be followed for the legal proceedings under EPA 1986. First, the notice must be delivered to the occupier or his agent, and it must indicate the intention or the analysis of the issue of a particular case. Second, samples of the extent of pollution to be checked must be taken in the presence of the occupier or the agent. Third, the sample should be sent directly to the laboratory without any delay in the process. Last, the sample should be kept in a container with a label on it, and it should have the signature of both the occupier party and the person taking the sample. The central government must recognize at least one or two laboratories under this act, and the report of analysis can be used as evidence of the facts stated in any procedure done under this act. As it was stated earlier, that the most important goal of the EPA is to provide for the punishment of the offense of endangering the human environment, safety, and health. Section 15 of the Act states that any person who is not complying to the provisions stated in this Act and its failure or contravention will make him liable and punishable as the following. First, in terms of imprisonment up to extension of the time span of 5 years. Second, with fine which may extend to the term of 1 lakh rupees. Third, or the liable person has to deal with both of the punishments. Fourth, if the contravention of the offense that continues for 1 year, the punishment can extend up to 7 years. Section 24, a provision that if any offense is punishable under EPA and also under other act, then the person shall not be liable under EPA 1986. This particular section reduces the punishment extent as other act includes lesser punishments. Section 16 of the Environmental Protection Act 1986 explains the principle of vicarious liability of the in charge person such as directors, managers, and secretary, etc., for if the offense is committed by the company. He is not held liable for the following. If first, if the offense is committed without his knowledge. Second, if he is or he has taken diligent care to prevent the commission of the offense. The Act has barred the civil court to entertain any proceedings in respect of any action taken by the central government. Most of the cases in India pertaining to environmental law have come to before the courts in the form of public interest litigation, which is PIL, and can be filed in high courts and supreme courts. Herein are the references that has been used to compile this lecture. Students can refer to these links in order to understand the topic better and further. Thank you and enjoy your day.